All rise. Here. Criminal Court of Davis County Division 5 is now in session. All persons having business before the court draw nigh, give attention, and ye shall be heard. God bless the United States, State of Tennessee, at this honorable court. Honorable Monty Watkins presiding, please be seated.
All right, good morning, everybody. We have our regular discussion docket with a few other matters on. We'll call through the docket. I'll take about a 5 or 10 minute break, and then I'll come back and hear what's ready. Okay, Madam Clerk.
Clearly Aguilar.
Tell them if they're going to talk, they need to step outside.
Mr. Aguilar.
Your Honor.
All right.
Jesse Allen.
Your Honor, I do not see Mr. Allen. I've never had a problem with being here. I'm trying to get in contact with him.
Temporarily ready.
Luis Alvarez Avila.
Your Honor, that's my case, and we'll need a translator.
All right.
Samuel Ashley.
That's also my case this morning. I don't see Miss Sands.
Well, we'll give her a call because this matter, something needs to happen with this matter.
Cory Batey.
Good morning, Your Honor. Mr. Batey is in custody, and that's the state's motion.
All right.
Yes, Your Honor, and Joan Norman will be here so she
Sure.
answers her docket call.
I'll hear that matter probably first.
Martarius Bell.
Mark that ready.
Patricia Beadham.
That's my case, Your Honor. Mark that ready, please.
All right.
Cortez Dryden.
Your Honor, case is said to be your momentarily, Your Honor.
Temporary ready.
Zacchaeus Britt.
Good morning, Your Honor. Mr. Batey is in custody. Please mark that ready.
All right.
Alex Oldham.
That's my case, Your Honor. He's in custody. Please mark the case ready.
All right.
Michael Child.
My client, Your Honor, if you could mark that ready.
Cordell Crutcher.
Mark that one ready.
Brandon Davis.
Temporary ready.
Marcus DiDonato.
Your Honor, Mr. Giovanni is also in custody. Please mark that ready.
Ronald Dunn.
Here.
All right.
Garrett Franklin.
Okay.
Mitchell Ross.
My claim is Mr. Ross, he is now in custody in Montgomery County, he's picked up some new charges. We could go 1 week and get a transport order and get him here next Thursday.
Well, we probably have to take Capia's.
I understand, I think E&W is gonna be here to try to get off his bond, and no objection to that.
All right. Okay.
Thank you.
Jason Givens.
Mark that ready, please. You can check.
Mario Bedoy Espino.
He's here.
I'll be handling that for Mr. Griffin today. We'll probably be picking a trial date today.
Okay.
Daryl Hale. Your Honor, Mr. Kors spoke with Mr. Hale this morning. He's coming up from Alabama and had a small issue this morning with his vehicle, but he should be here around 10:30.
Who? Which one?
Mr. Hale.
All right.
James Hurt.
Temporary ready.
Your Honor, he's in custody. Mark that ready.
Cameron Jordahl.
Mark that ready for Mr. Kincheck.
Peter Lewis, Samin Nashed, and Salim Hodgers. By agreement, those have been continued to next Thursday, September 22nd.
And Judge, I could explain, just for the purpose of the record, the reason for that is that we're going to have the co-defendant sentencing hearing first, and then these three gentlemen's cases, but the sentencing got out of sequence because of the trial. So I think the sentencing of the defendant is tomorrow, so
All right.
hopefully next week we'll.
All right.
Bobby Majors Jr.
Okay.
Edward Moore.
Miss Alexis, this is my first time seeing you here on this matter. It's been said a number of times. Oh, yeah, something's going to happen today. That's for sure. All right.
Randall Morris.
Your Honor, Mr. Morris is in custody. Please mark that ready.
Michael Newhall.
Here.
My client, Your Honor, mark it ready.
Kelvin Newsom.
This is my client. He had heart trouble. He called right before I left the office and said he should be here momentarily.
Temporary ready.
Oliver O. Or O.
That's my client, Your Honor, mark it ready.
Gary Parks. By agreement, has been continued to October 20th. Rita Risley.
My client, mark it ready.
James Robinson Jr. by agreement has been continued to October 20th. Shankia Scott.
Okay, what's your status on an attorney?
Come on up, ma'am.
You're still looking? Well, that's what we gave you the last time. It's time to get someone. Let me get you to fill out an affidavit, then we'll see what we can do. All right?
Jontez White.
Your Honor, that's my case, and that's the co-defendant, Ms. Scott.
Fatten Sharpley.
She is here, please mark that later.
Jeremy Smith.
All right.
Reginald Smith.
Mark that ready.
Misael Soto Garcia.
Mr. Soto Garcia is in custody, Your Honor, and he will require services from the
Okay.
Andre Sweat.
All right.
Thomas Taylor.
No answer. Temporary ready.
Shawanda Weems.
Judge, President Court, if you can mark that ready. And also, Judge, Mr. Newsom on page 14 walked in right after you called him.
Well, you know, I did the order on her last week
Yes.
sometime.
And I'm sure General Anderson will be here and we'll discuss Ms. Weems' case.
Okay.
Michael Wright.
Larry Fest, Mr. Wright, he's present in court.
All right.
Nicholas Stewart.
He's present in the court, Your Honor, if you can mark it ready.
All right.
Ryan Bowden.
Mr. Johnson.
Okay, ready.
Oh, I'm sorry, Your Honor, yes, sir, Justin Johnson, Mr. Bowden.
One of those senior moments, huh, Mr. Johnson? All right.
Trevor Greer.
Temporary ready.
Megan Ladd.
That's Mr. Bowden, the co-defendant of mine.
Well, I heard somebody else speak up. Is that?
She's here, she's waiting for her, Bobby Dowd.
She's waiting for him.
Yeah.
Well, she needs to be in the courtroom. She can answer the docket, but she shouldn't be outside the courtroom waiting for him.
I'll tell her to come in, Judge.
All right.
Lori DePriest.
Temporary ready. Call Binkley bonding on that matter.
That's the call for Dr.
Okay. As I said, we're going to take about a 10-minute break, and then I'll come back and start hearing matters.
All rise. What would be a brief recess?
Anybody coming late, did not hear your name called, come see me.
We might have a problem on our docket. What's that?
Did you hear what I said about Newsom?
What?
Yeah, sure she can.
She wasn't there at the college. There were some, Julie, the time she showed us.
I'm sure she'll be there by the time you get out here.
You got it.
Happy birthday, Gavin.
Thank you.
All right, Matt.
Thank you, thank you, thank you.
I got that paperwork prepared.
My Lord, let me get on the day before this starts.
Everyone can remain seated, but please come back to order. Court's back in session.
All right. State's motion on Mr. Batey.
Yes, Your Honor, thank you. Please score, obviously know the court has reviewed the motion and matters we've submitted with that. We do have one additional matter that I've provided to counsel this morning that I would tender to the court. If there's somebody to tender. Affidavit of General Thurman, which again has been provided to counsel, would ask to be included with the record of this case along with the exhibits that were attached to our motion to be a part of, as I said, the exhibits and record in this matter. This is a matter that the state brings with all due respect to the court, because the state does not believe the court has had any essentially impropriety in and of itself. It's how this matter came to light. And that for the first time, as we set out by General Thurman's affidavit, that as the court was pronouncing the sentence, referenced letters the court had considered, and that were letters, what letters? So I thought perhaps we should investigate and or at least make an inquiry, which we did to Ms. Halstead, who advised that yes, letters had been submitted by various individuals to her to be routed to the court. Those were never attached to the pre-sentence report, nor mentioned in open court by counsel during the sentencing hearing, nor attached to any sentencing memorandum, nor provided to the state. The import of that was that, among other things, the court may recall General Thurman argued that, well, while the court had heard testimony from persons here in court about Mr. Batey and his good character, that the court had heard nothing from his peers. Well, unbeknownst to us, the court had received letters from his peers, which the court acknowledged having considered in this matter. Certainly, we would have addressed that. We would have had the opportunity, as under State v. Biggs, which is cited as a footnote in our motion, that what happened here was in derogation of what should have happened, again, by the state not being provided with these either by counsel, by the pre-sentence writer, who perhaps may not have even had them either, or through any other method that, as State v. Burge says, in dealing with letters received by a trial judge, whether in chambers or in open court, should be filed, made a public record, which I believe they perhaps are now with the filing of them as exhibits to the state's motion, so that the respective parties can read the letters, be considered, be taken where in this format, as they said, this format of openness, avoid the appearance of any potential impropriety or appearance or anything like that of, namely, being influenced by the letters received in chambers, which again goes back to the state's, and I would submit, most respectful position of whether or not it is up to the court as to whether the court should disqualify himself or itself, rather, for any further participation in Mr. Batey's sentencing. Counsel for the defense certainly quotes law that the state is quite familiar with, which is the sentencing under sentencing appeal 4035-402, appeal of sentence by state. Certainly we're aware of that. But felt, though, that the state should give the court an opportunity, as the state has and defense has on many, many occasions where something may have come to light, where a statute was overlooked, and where the court sentencing, instead of just sitting back and saying, well, we're going to appeal this, we're going to file things and appeal, to bring the matter back to the trial court, one, to build a record, but two, to give the court an opportunity to address the issue and have an opportunity for the court to make a decision, a ruling in this matter, under this framework. So, to the extent that this could be called unprecedented, I would disagree with that. Perhaps the publicity associated with it is unprecedented, but to bring a matter back to the court's attention while the court still has jurisdiction, I submit, is the proper thing to do, and what we felt was the proper thing to do to address this, and that given the circumstances, we would ask the court to set aside the sentence, and if the court feels necessary, recuse itself for any other matter regarding a resentencing. But we would also ask, and obviously only the court at this point would know, that if there have been submitted, if there are any other letters that the court received from any other people or any other medium in this matter, that those be made a part of the public record and provided to the state for review. But that is why we were here, with all due respect, is because the state, we feel, did not get a fair playing ground, a level field, so to speak, to engage upon the discourse and the sentencing hearing that was conducted in this matter. And for those reasons, we would ask the court to grant the motion. Thank you.
I know the court has had a chance to take a look at these letters. I can't imagine how the state was disadvantaged on July 15th when the sentencing hearing was conducted. These letters are really innocuous. They could not have reasonably or materially affected the calculus of this court's sentencing decision. I looked at the transcript. There was no contemporaneous objection when you made your findings at the end of the hearing. I won't read these letters, but I wanted to summarize for the court, and I know you're familiar with them, the content, the innocuous content of the letter. I know that General Thurman has filed an affidavit this morning where he says that he may have called witnesses to rebut some of the sentiments contained in these letters, but these are personal opinions expressed by people that know Mr. Batey. For example, there was a high school friend explained to the court that Cory Batey was a friend of her older brother, liked his smile and said that he was polite, that he was respectful of adults. There was an Ensworth parent whose son was a freshman when Cory Batey was a senior. They played on the football team. She makes innocuous comments that she always found Cory Batey to be respectful, nice, thought he was a talented young man. Another individual wrote a letter or an email to the court saying Mr. Batey was kind and respectful, and these actions were out of character. I don't know who the state could advance as a witness to rebut those type of character traits. General talked about some peers of Mr. Batey. There was a letter from a former high school classmate, a friend and a teammate. He said he certainly did not condone the conduct in the case, but he did express to the court that it was out of character. He was concerned about the state's request for a 25-year sentence. There was an English teacher who characterized him as a gentleman both in the classroom and outside the classroom. Talked about how he behaved at school, that he was always respectful. He talked about his mother a lot and how much he valued her. Talked to her about the loss of his father. But she wrote in the letter he never tried to make any excuses about his conduct and was remorseful. There was another from another peer, a short email, 3 sentences that basically was a plea for mercy, not based on the facts of the case at all, but the fact that he has a young child. And the state was able to fully comment on the fact that Mr. Batey had a young child and that the child was born after these events. There was another teacher that wrote a letter to the court saying there was no effort on her part to condone any of the acts, that she knew Mr. Batey as a different person, that he was a loyal and authentic person. Then there were 2 ministers and evangelists from the New Metropolitan Christian Missionary Baptist Church who indicated that Mr. Batey had expressed remorse. There was Johnny Grimes who testified here in open court. So the state had a full opportunity to cross-examine Pastor Grimes. He wrote in his letter basically what he had testified here in open court that Mr. Batey had apologized to the victim and had asked for forgiveness, and that he had apologized to the congregation. There was another parent from Ensworth who made the comment that Cory Batey was a pleasant person, and she felt like his remorsefulness was sincere. There was another teacher that had sent a cover email, but the record does not reflect that the letter was ever attached. I think what this is about, Your Honor, and I say this respectfully, is evidently the state was not satisfied with the sentence that the court imposed, being the minimum in the range. And this is basically an attempt to get a second bite at the apple, and it's basically an attempt to try to get a second bite at the apple with a different judge. I noted in my response that the state is dissatisfied with the sentence that the court imposed. There is a procedure that they can follow. If they feel that in any way that within range sentence failed to meet the statutory requirements, they can appeal it. They are familiar with 4035, 402. They can speak with the State Attorney General's office and they can do an appeal of the sentence. But to wait 30 days when this judgment is about to become final and then file this motion, which I think really is a manufactured reason to suggest that there needs to be a new sentencing hearing. Again, I don't know how they would have cross-examined these people if they were in court. It would be trying to cross-examine a Hallmark card with these kind of sentiments that are being expressed, that someone is respectful or polite, or they think that they're a nice person. As I mentioned, there were two character witnesses that were advanced by the defense at the sentencing hearing, Pastor Grimes and Pastor Thomas. The state had an opportunity to cross-examine them, and I think General Norman effectively confronted and cross-examined both of them. Mr. Grimes, Pastor Grimes, she challenged the frequency of Mr. Batey's attendance at church. She brought to the court's attention that really Pastor Grimes didn't know Mr. Batey that well, that he had limited knowledge, had never seen him in a social setting. The state was also able to challenge his opinion of good character of Cory Batey based on the proof in the case. And the state was also able to point out through Pastor Grimes that there were inconsistencies in Mr. Batey's version of the events in this case. So they had a full opportunity to cross-examine him. Pastor Thomas was also advanced by the defense at sentencing, who, quite frankly, after cross-examination, his testimony was diluted by the fact that he didn't really know Mr. Batey, certainly didn't know him prior to these events and had no social contact with him. And where the state was able to challenge the completeness and candor of Cory Batey's confession, if you will, or statements of remorse to Pastor Thomas. So for all those reasons, I would ask the court to deny the state's motion for a new sentencing hearing. Again, they have a remedy if they choose to pursue that remedy. There's been no showing that any witness could have been advanced to successfully rebut the kind of innocuous sentiments that are expressed in those letters.
All right, thank you.
Just very briefly in response, innocuous sentiments are one thing, but in one of the letters the counsel has just referenced, one submitted by a person named Shamari White, that person wrote, I'm not quoting, quote, "I feel that this sentencing is also too much because just recently a white male committed the same exact crime as Cory Batey did, the Stanford swimmer, and he will do a couple of months in county for raping a victim behind a dumpster with no remorse." So on and so on. That is something that certainly the state would have addressed. And counsel was saying about what the sentiments were in the court's consideration, but the point of the matter is that it was the process that the state was disadvantaged by, of not being allowed to address these issues and or comment, because comparing this matter to whatever happened in some other state and some other person, if that had been part of this, apples to oranges would have been probably mentioned, since we're talking about fruit. It's the process. And again, going back to the Burge case versus, that's the whole reason for the parties to be able to, in open court, in full view, with both sides having a fair playing ground, to address these matters. It's the process, not Your Honor, it's the process that was flawed in this matter. And second bite at the apple, well, when you don't find out until it's after the fact that your apple had a worm in it, then you're entitled to a fresh apple, I submit. Thank you, Your Honor.
All right. Thank you both. Well, as is customary on sentencing day is when I receive letters, character letters and pre-sentence report and sentencing memorandums, and I read them that morning. I don't read them beforehand because usually I don't have all of that material before me until the morning of the hearing, as I did in this particular case. Anyway, what I'm going to do is take this matter under advisement, issue a ruling sometime next week, a written ruling, and then both sides will know, the world will know it, for that matter. So thank you both.
Thank you, Your Honor.
Okay, we'll take a short break and then some other matters.
All right.
We're in a brief recess.
Roger. Darryl Moore.
Yes, ma'am.
Yeah.